The authorization for financial assistance is pretty much what you'd expect. We have the possibility of the members approving financial assistance, and we have the possibility of the directors approving a limited amount of financial assistance. So first of all, if the financial assistance does not exceed 5% of the paid-up capital and reserves, then the directors may resolve to make the assistance, provided that they decide that the company really should give the assistance, it's in the best interest of the company, and the terms are fair to the company. The members may, by written resolution, approve unlimited financial assistance, and the only reason why this provision in 284 requires that all members approve is simply that when acting by written resolution, that's something like an email sent around, reply to all sort of a thing, it will always be all members. Unanimity is required. However, if we have a meeting, we may approve unlimited financial assistance with a ordinary resolution, a majority of the members. And so the barriers to financial assistance are not extremely large. And however, if some members holding up to or at least 5% of the voting rights of the company object to this, they may take it to the court and seek an order restraining the provision of the financial assistance. Reduction of share capital is in many ways the object of the protections that we've seen in each of these distributions, whether it be dividends, repurchase of shares, or financial assistance. And so now we're going to the heart of the matter. We have a laundry list similar to the laundry list of capital increases we find in Section 170 of the company's ordinance, and this time the laundry list is in Section 210 of the company's ordinance. And we see that the share capital may be reduced by extinguishing or reducing liability on partly paid shares. So we have agreed to pay in 100 per share. We have only paid in 80. We owe the company 20, but the company then agrees to extinguish that 20, reducing the share capital to the quantum of 80 times the number of shares issued to us. It's also possible to cancel shares not represented by available assets. And this would be if the company is losing money. And remember, I mentioned that the share capital will be technically placed on the liability side of the balance sheet, and that's to ensure that the liabilities plus the share capital will always be at least equaled by the assets. And so if the assets were to be reduced by losses to the point where the share capital plus the liabilities are no longer covered by assets, then what we could do would be to decrease the share capital and thereby decrease the liability side of the balance sheet, which would in effect move funds over to the asset side of the balance sheet, and that would allow the company to continue to exist in a solvent manner without adding extra funds to the company. It would look a bit like sort of decapitalizing share capital. We talked about capitalization, and this would be taking funds out of the box that's called share capital, placing them back into the assets of the company in order to counterbalance the liabilities. And we can repay paid-up share capital. This would be something like a refund. This is exactly what the law is designed to avoid, and this is why we do have a very particular set of requirements in order to have a valid reduction of share capital. So the approvals that are required are relatively extensive. So first of all, we can prohibit a reduction of share capital in the articles, and the model articles do not. We must approve this by special resolution, a slightly higher standard. supported by a solvency statement made by the directors. We discussed that earlier. Or we can take the other side of a fork in the road here, and we may go right to the court and ask the court to approve a reduction in share capital. So for a reduction in share capital, we have two possible routes for approval. One would be to ask the directors for a solvency statement and ask the members to approve by special resolution that the share capital will be reduced. And the other is to go directly to the court and ask the court to assess whether a reduction in share capital is possible. The solvency statement used in seeking a special resolution must be no older than 15 days before the meeting and be made available for inspection at the meeting. And if the reduction regards only some shares, the resolution cannot be adopted only by action of those shares. And if we do have a resolution, if we don't go to the court, then the resolution must be filed, creditors must be given notice, and there will be an opportunity for challenge. And if no challenge is made, the court can confirm the transaction, and we would need to file a return on the reduction of share capital with the company's registry. So let's look at this notice and challenge a little bit more closely, because this is what is specific about the reduction in share capital, right? So if we will follow the private route, that is a special resolution, it's necessary to publish a notice in the official gazette. That's a sort of a Facebook of the commercial world, used originally in the 19th century in many countries. If you were to look at the Financial Times or the Wall Street Journal, they perform similar functions. These commercial papers often publish official notices, and the Gazette is a public medium to provide such official notices. So the creditors would be given notice, they would be given some time, and they would then take their complaints, if any, to the court. The solvency statement would also be made available, because the solvency statement is key in deciding whether the reduction of capital should go forward. The creditors are not given a vote in this decision, but the creditors are given the right to go to the court, which then may overturn the special resolution. If the court either confirms or cancels the resolution, it may do such on a very broad range. That is, it may look to any terms and conditions it thinks fit. So the court is given a very broad discretion in these matters. And the company, however, if it thinks that there may be a challenge to its special resolution, may decide simply to take the matter to the court at the beginning. And in this way, the company would be prepared for the court proceedings, and the creditors would have to react to those court proceedings after the fact. So simply, if the reduction is unproblematic and the company is extremely solvent, it can be done privately with notice to creditors. The creditors would not object, and the court cost would be spared. If the matter seems to be borderline, then the company strategically may choose to go directly to the court and prepare itself for a battle with its creditors. That was the lecture for the protection of creditors on the basis of capital maintenance. And next week, we'll look at the protection of creditors through the extraordinary tool of piercing the corporate veil.